SJC-11862, Commonwealth v. Richard St. Louis.
Good morning, Mr. Chief Justice and Associate Justice of the Supreme Judicial Court. In this case, Mr. St. Louis is entitled to entries of judgments of acquittal or not guilty on the charges which he was committed. And I'm specifically addressing the indecent assault and battery on a person with an intellectual disability charge. That is the gravamen of the defendant appellant's argument. The term intellectual disability is not defined by law. And
well, it's not in Chapter 123B, Section 1?
Yes, but that is not...
it's a law.
It is a law, but it is not necessarily an applicable law to this case. For the purposes of the criminal law, which you're going to impose criminal sanctions on, there's no definition of intellectual disability here. Once again, the court would look to, and counsel would look to, laws where it is defined. But there's nothing in 123B that says that is the definition of indecent assault.
Do you think before it was amended in 2010, because it didn't also define what mentally retarded meant, was it also void for vagueness?
Yes, and that point has been brought up by defendants in the past, but there was a generic or popular understanding of the term mentally retarded. That term was in common usage. It was a perfectly legitimate term, but it was also used as a term of
Isn't it clear from the legislative history that the goal of the statute was to remove, was not to change the substance, but simply to remove a term that was pejorative and not appropriate to be used?
Well, that is certainly one function of what the legislative history reflects. But that legislative history is actually very narrow when the court looks at it. It just simply said the term mentally retarded or is purged. It is purged from the statutory law. It is now an offensive term used in its policy usefulness is no longer there, and it's a pejorative term in common usage.
Was it purged at the same, were the changes to Chapter 265, Section 13F made at the same time that intellectual disability appeared in Chapter 123B, Section 1?
Yes, it was that the legislation which changed the term from mental retardation to intellectual disability was comprehensive, but it infected many statutes, but it did not go further than that. I would call it a search and replace amendment, where you just take this term out and put in a new term. Other than that, there's no substance to it. And I would point out, in terms of 13F, it still retains the term mentally retarded.
No,
last paragraph, yes.
Yes. So under normal statutory interpretation, there should be different meanings of those words under Commonwealth versus why not.
The person in this case was under a guardianship.
Yes.
What are the standards for a guardianship, getting a guardianship of a person who's suffering from an intellectual disability?
Well, I think I don't really practice in that law that much, but it was clear from the testimony that you need assistance in terms of your personal care needs, and you can't do that by yourself. You're not entirely capable of independent living. You need someone to handle your financial affairs, maybe medical affairs. Adoptive life skills, as that term would be used, perhaps.
Didn't your client specifically say, I mean, there was a question put by the prosecutor about intellectual disabilities, and he said, yes, I know that she did have them?
Yes, they knew each other, and I mean, I certainly cannot...
Well, but I mean, he used that term. He adopted that term, intellectual disability.
Yes, but I don't think that, I mean, he knew that she suffered some mental impairment. But I don't think it's a knowing use of a technical term there, what an intellectual disability is. I mean, I don't know what an intellectual disability is for the purposes of this law, because it's undefined. It's a large term. It's not simple mental retardation. It can imply to Alzheimer's, head injury, various other injuries. It simply means your mind can't do something. It's not synonymous with mental retardation necessarily. Bigger, larger concept, more abstract.
Would the person in this case have been would the person in this case have had the capacity to get married?
That's a possibility, because
Is there anything in the record that goes to this?
well, what goes on is that she was questioned in terms of she knew where babies came from or something to that the records indicates that she was a mature woman, presumably sexually mature, and that she knew where babies come from, and she had an understanding. She took care of children. She did, I would, reading the record, had some understanding of sexuality. And in terms of her ability to marriage or have personal relationships that might have some sexual capacity, I believe that she would do that, and that, in fact, would also be a constitutional right of hers, and that could not be.
She did have an IQ of 47, and that was part of the record.
I'm sorry, Your Honor?
She had an IQ of 40. It was tested as
It was
47,
tested.
and that was part of the record.
There is specific information in terms of her IQ. The Commonwealth did put in evidence of that, but once again, that does not exclude sexual conduct.
No, I am not suggesting it does.
No.
I'm just
Yes.
saying that
There
in
was
terms of
evidence in the record.
her intellectual capacities were limited.
Yes.
Did she have a job?
She did not have employment in terms of going in a 40-hour job and receiving a paycheck on that record. But there's evidence that she did take care of children while she was at school and probably helped around the house. But, she was not part of the standard issue.
It was a class she took it was a class she took in a special ed program, right?
Yes. She did not get a full high school degree, but she did attend school as long as school was available to her, and there's all indications that she did pretty well at school.
Were there modifiers of the term intellectual disability used during the trial, such as they used to use the term severely retarded, moderately retarded? Were those modifiers used with respect to intellectual disability?
Candidly speaking, I don't know about the modifiers. I simply don't remember if that was in the record or not. There was evidence of retardation.
I don't think
so
that.
to speak.
Well, let me ask you this: there were medical records in evidence, right? Were they about her intellectual capacities?
I think as far as I know, the medical records were the records of her guardianship from the probate court. Medical records per se, in terms of medical doctors, that I don't know.
Okay.
There was evidence of that. There was not, to my knowledge, a separate diagnostic exam of her taken after the indictment.
Now, at trial, did she testify?
She did testify. Your Honor.
And what did she say with regard to the issue of consent regarding the so-called indecent assault and batteries?
Well, she testified not in terms of the incident which generated the complaint, and I would like to I do make that very plain in my brief that the incident on the porch, there was no evidence of her lack of consent on that, and there's no evidence that she's incapable of consenting. Now, in terms of the other offenses, and we don't know when they occurred, she said not comfortable. He told her not to tell. One incident, he put her head down toward his lap. But once again, that goes to a different charge, I would submit. That would go to indecent exposure, perhaps annoying and accosting. Her lack of consent defense was, I feel uncomfortable, or words to that effect. There was evidence. There was not much evidence. And in terms of the actual incident that happened in September, there is no evidence of lack of consent. That's a voluntary action.
Was the defendant a recipient of any services from the name of the department? I can't remember. The defendant. Was the defendant a recipient of any services from, like, the Department of Mental Retardation or whatever it's called now?
Well, the complaining witness.
No. I mean, was the defendant?
Defendant, no. To my knowledge, no. No, he was employed. He was a 73-year-old man. He was skilled. He's not highly educated, but he developed a skill that apparently allowed him to be married and have children and have leisure time.
Army veteran?
Yes, Your Honor.
Or
Yes,
Air
and
Force
no
veteran?
prior record as well. So he was a full functional adult. But I would also point out, in terms of the ex post facto provision of this law was just simply became law on November 2nd, 2010. These acts were committed before that substantially, but we don't know when. That law was not even in effect during most of this encounter with the defendant. It did not exist.
But the law relating to the same statute using the term mental retardation was in effect.
That law was in effect up to that point, but there was no indictment in terms of mental retardation, nor was there an instruction in terms of that to my memory of the record. In fact, the judge used the mental impairment instruction from Section 13K.
So you're saying he should have been charged under the prior statute?
Yes. He should have been charged under the prior statute where they believed that there was a possibility that this would occur, and then it would be a fact for the jury to find, and the jury to be so instructed. Not for the second incident where that clearly happened after the intellectual disability part of the law was in effect. And that is confusing, and I would point out in terms of the vagueness argument, there was a lot of confusion on the part of this where the trial judge had to look around for a definition of intellectual disability.
Nobody suggested to him that he look at 123.1?
No. I don't see it. I think the judge decided, I don't know what that means, so I'm just going to go to the next law, and that seems to do the trick, and no one objected. Defense counsel didn't object or anyone else. Everyone said that was fine. But once again, it's not fine. It's ineffective assistance of counsel because the defendant in this case was convicted of a charge that he was not indicted for. And there was confusion on my part, and I admit that because I really didn't understand that until I filed my reply brief, that he's actually convicted of 13K with the instruction. And he was never indicted for 13K.
No, he wasn't, because it was part of the instruction in 13K. The judge only used mental impairment. He didn't use the other impairment.
Yes, but intellectual disability and mental impairment do not necessarily mean the same thing, especially if you're going to rely on the term mentally retarded, as that term was used then. Mental impairment, once again, is vague, can mean anything. It can mean you're too smart, like Rain Man. It can mean Alzheimer's. It can mean...
But does it mean that under Chapter 123B, Section 1?
No, that is a statute where you define what was the term mental retardation, not intellectual disability. But that term was new to the law. And if you look at the Code of Massachusetts regulations, there was a gradual development and incorporation of that from 2010. I don't mention it specifically in the brief, but the court could take judicial notice that it started in federal law in 2010, and then it was simply adopted by Massachusetts as terms of the new term, Rosa's Law. And then the Code of Massachusetts regulations followed that, but slowly.
In substance, is there any difference between the former term mental retardation and the current term intellectual disability as it appears in Chapter 123B?
And 123, no, I'd have to say they're similar, but you would still have to look at the Code of Massachusetts regulations that even now it says you should use expert testimony, and there's some clarifications in terms of that. It's a different, 123 is about provision of services, okay? This is criminal law. I mean, I know that they're similar, but you have to look into the rules of the criminal law and lenity and specificity. It is used. And the court did not use, or at least the appeals court did not use a scientific definition as used in 23B to use the term mental retardation. They used a more commonsensical understanding. But that can't apply to the term intellectual disability, which was not in the law at the time of most of this case.
Let me ask you this.
It's novel.
If you just assume hypothetically that the new statute, the amended statute, is considered substantively the same as the old one. Mm-hmm. With respect to the incidents, not the one on the porch, but the prior incidents, what's your view as to the sufficiency of the evidence of lack of consent there?
Well, I would have to say that I would certainly admit that there's record evidence at least, but I don't know whether that is sufficient. I think the Judicial Court might consider that, but I mean, that's not a clear issue. I would say the evidence is quite modest in terms of that at best. I don't feel comfortable, something like that, when she's an adult there, and I don't know how much you want to expect of a person in her circumstances, But I would say clearly, it's very close to a required finding of not guilty, even under the best of circumstances.
Did the jury instructions give to the jury the question whether she was capable of consenting? Is that how it was phrased?
And that issue.
It was just whether, in fact, she did consent or not? Was that how they were?
That was the jury instruction. So that whole issue of being incapable of consent because of profound mental retardation or other disability is not there.
Okay, it was just, did she consent or not?
Yes.
But there was an instruction about what they could consider in connection with whether she consented, right?
Yes, I mean, there was an instruction in terms of a specific definition of what consent was in this case.
I don't have it in front of me, but part of that had to do with her mental condition, yes?
Yes, and the jury could consider that, but once again, that doesn't exclude consent on her part.
Okay.
Thank you.
Thank you, Your Honor.
Good morning. May it please the Court. John Bossé for the Commonwealth. The Commonwealth respectfully requests that this Court affirm the defendant's convictions. It is our position that the term person with intellectual disability is not unconstitutionally vague because we derive at the meaning of the term from other statutes as well as dictionary definitions.
But is it the same as mental retardation?
It's a Commonwealth's position that it is, that there.
It is not more expansive than mental retardation
Would somebody with Alzheimer's fit within that definition?
of intellectual disability?
Yes.
Okay.
So
But
then
not
it is
mental
more
retardation.
expansive, right?
Well, they're virtually the same. Under 123B, Section 1, they both pertain to an individual who has substantially limited in the ability to learn and adapt.
What about dyslexia? Is dyslexia an intellectual disability under 123B?
No.
Why not?
The individual still has the ability to learn and adapt.
But the judge didn't charge under 123B. He gave a definition of intellectual disability under 265.13K, right?
Correct.
Which
So,
really is different.
well,
Maybe. Words are different anyway.
our argument under constitutional vagueness is that you can derive at the meaning of a term from other statutes, so you arrive at the meaning of person with disability from 265 Section 13K, and the word intellect, again, that's kind of like a common sense argument. I mean, you derive at the meaning of intellect from a dictionary definition. That's our position with regard to the unconstitutionally vague. With respect to the ex post facto argument, our argument is that the two terms are synonymous. The only thing that changed was...
What are synonymous?
The term mental retardation is synonymous with the term person with intellectual disability, and in support thereof, I conducted legislative history research at the State House Library, and I didn't find much, but what I did find was a State House news article in which they interviewed both the governor and a state representative, and they said it was simply, the entire general law was amended to replace the word, to take out the word mental retardation, replace it with the word person with intellectual disability.
What do you say to Mr. Hickson's point, which is true, that the statute still uses the term mental retardation in the last paragraph?
That seems by error. Everywhere else in the general laws, the term mental retardation has been taken out and replaced with the term person with intellectual disability. And that State House news article goes right to the point and says this was done to promote dignity and respect for people with intellectual disabilities.
So are you saying that going forward, the term should be limited to those who would previously have been classified as having mental retardation?
Yes, Your Honor.
So that wouldn't include people, for example, who have Alzheimer's?
Well, right, so going forward, but I guess technically it could include people with Alzheimer's because, people's Alzheimer's have difficulty with the ability to, depending on the day, I guess, to have difficulty with ability to think, to adapt to different environments.
So I guess I'm just really confused here, because before you were talking about, you were agreeing that the person of intellectual disability, I guess that's the term, right, is a more expansive term, therefore not synonymous with mental retardation. And now you're saying it's not an ex post facto problem because mental retardation is in fact synonymous with person of intellectual disabilities. So which way is it? Are they or are they not synonymous?
My position all along in my brief has been that they're synonymous.
Well, if they're synonymous, then it's limited to people who otherwise would have been characterized as having mental retardation, and only that group.
Right, but when I was...
I'm saying that so what is it that we're to hold here in terms of the definition? That it's limited to those who would previously have been categorized as mentally retarded, or that this person of intellectual disability is broader than that, can encompass other people who, if you're using a functional definition, would be inclusive of people, for example, who suffer from Alzheimer's.
Right. I think we have to go...
This means synonymous.
I think we have to go with the legislative intent, which was that it only include people formerly classified as mentally retarded.
I'm going to change the topic, if I could, a little bit. The indictment charging the incident happening on the porch, where is the evidence of lack of consent?
The evidence of lack of consent is that she testified that the defendant made her touch his private, as well as...
First complaint evidence. That wasn't direct evidence.
Well, the evidence of lack of consent is the difference in sophistication and age level between the victim and the defendant.
On this incident, I'm sorry, I don't see...
Well,
there's no evidence that he made her touch his private.
Right, so, well, she did first complaint test,
Doesn't count.
okay. But the evidence is that the fact that you have a defendant who at the time is around 70, at the time of trial he's 72, so at the time of the incident he's around 70, and he's letting this individual who has an IQ of 47, touch him inappropriately. He's just letting her.
Well, the cases that you cite are about adults inducing children to touch them. Are you suggesting that he induced her to touch him?
No, but I'm suggesting the fact that he allowed her to, well, it's unclear.
So does that mean a person with that kind of IQ can have no sexual relations with anybody?
My position is that an individual, based upon the evidence at trial, an individual with an IQ of 47, an individual who a parent has guardianship over her, an individual who disability, the mother testified to, was classified as mental retardation, that she can't consent.
But she could never have a sexual relationship with anyone because she couldn't possibly consent.
Yeah, that's a good question. I think it depends on the level of disability. This individual, and you got to look at the entire circumstance. If you have I don't believe an individual like this could consent to sexual relations with another individual who doesn't suffer from either the same or similar disability.
What do you base that on?
Common sense.
Common sense?
Yeah.
Really?
I do, Your Honor. I mean, why? It places an individual in the position,
Doesn't that take away completely any autonomy of this human being?
Well, I think you have to look at it very similar to a child, that they're unable to consent.
Right, but the law is quite clear about that. Where in the law does it provide the crime of statutory rape to have sex with somebody who has an intellectual disability?
Nowhere, but the judge did instruct on it that you can, in terms of the consent, you can consider the entire circumstance.
Okay, but there's a difference between the lack of consent being circumstantial and your view that even if she did consent, that consent is of no legal consequence because the circumstances require a finding of lack of consent regardless of what her state of mind was.
Yeah.
I mean, the concern I have is the consequence of your argument would be to criminalize the act of sex with any person with an intellectual disability. It would make anybody who engages in sex with somebody with an intellectual disability a criminal. And tell us where the law says that.
Well, it comes down to an issue for the jury, and you need a similar instruction that you had in this case, that you consider the entire circumstances on whether or not she consented. And the jury can take into consideration evidence of her IQ of 47, the fact that she has been diagnosed as mentally retarded, in determining that she was unable to consent to these sexual activities with
She was unable to consent or did not consent?
Did not consent.
So she has a $10 bill and walks up to a male prostitute on the street and says, I want to have sex with you. He takes a $10 bill and they have sex. He's guilty of rape.
It depends on what the evidence was of her mental disability.
Well, let's assume it's the same person.
I would say yes.
I mean, I guess the difference between that particular incident and the prior ones, it seems to me, is that I could find in the record, excuse me, absolutely no evidence of, apart from whether she was capable of consent, no evidence of actual lack of consent. I mean, the other ones, she said, I was uncomfortable several times and in several different ways. But with this one, there was nothing other than the first complaint evidence.
Right, but the fact that he allowed her to keep her hand on his private part without stopping her,
Oh, okay.
Yeah, but Justice Spina, I apologize. To get back to your question, I think, with regard to the prostitution question, that would just have to be left to the jury, in terms of considering the entire circumstances and whether or not she consented.
I don't know whether we're looking at, though, I think one of the problems is, why are we looking at whether or not she could consent or whether or not she did consent? And what does the instruction to the jury tell them to do?
It says that the instruction was without her consent or her ability to resist.
So the jury could have either determined that she did not have the ability to consent and therefore did not consent, or that she did have the ability to consent but she did not in the circumstances consent.
At the very least, I think it was for the jury to determine that she did not have the ability to consent.
Mm-hmm. And consent is an element of the crime.
In this case, it was, yes, because she was over 14. But, because she was very much like a child, I would say that, she could not consent based upon these facts.
But the jury was never
Right,
never received an instruction as to what it would mean to be incapable of consent, as they would receive for a woman who was unconscious or so drugged out or so drunk as to be unknowing of what was going on. There would be an instruction about being incapable of consent. I gather there was nothing here.
Correct, Your Honor.
Well, it sounded a little ambiguous as you were just, it seemed to include both, but could you say it again? What it
Yes.
was?
You may consider all these circumstances in the entire sequence of events in determining whether the indecent assault and battery was without the victim's consent or her ability to resist. And that's at transcript, volume 4, pages 240 to 241.
So does that mean that the jury was permitted to take into account the prior instances in which there was some evidence in which the complaining witness said that she was uncomfortable and didn't cooperate and so forth, and bring it forward to the instance on the porch?
I believe so, because he says you may consider the entire circumstance.
And meaning the entire set of alleged conduct
Uh,
over time?
Correct. That would be the Commonwealth's position.
Okay.
All right, thank you.
Okay. Thank you, Your Honor.